that's one strategy to help with managing poor performance, but obviously that's also in place to support people that are performing, to give them feedback. What are some of your other strategies you can share with our viewers as to how to manage poor performance?
Okay, so when you're going into an underperformance meeting, that's totally different from a performance appraisal. So, I see this a lot. People or managers or even employers, they're often very reluctant to address poor performance issues until it gets to be a huge issue, and then they want to fire the person on the spot. So when they phone me and they talk about, I'm wanting to terminate this person, I really have to backtrack from there to ensure that they have managed it effectively, and if they haven't, we'll talk about their risk involved in terminating a person's employment, because that is very serious stuff. So I guess you need to identify the problem and be very specific about what it is. So, for example, if a salesperson or a sales consultant isn't achieving their key performance indicators, they may be achieving some, but then others they're not. So you need to talk about that and be very specific about what those KPIs are and how they can perform better, and give them a reasonable time frame to improve their performance. That is to ensure that you're complying with the procedural fairness arrangements. So, tell them how serious the problem is. So if they're not meeting really important KPIs, it could lead to termination. So you need to advise them if they don't improve their performance within the required time frame, you may consider termination of employment. So be really clear there and talk about the gap, the performance gap, and how they are going to actually plug that gap. So in terms of what they need to do in what time frame to actually meet their performance standards, and then once they're up to standard, you'll then talk about how they can be very effective in their performance. If this meeting is the second or third meeting and you're talking about the same thing, you would reasonably consider termination. So at that meeting, you need to offer that person a support person. Now, in saying that, a support person can be a union official, a union delegate, they could be the wife, the partner, they could be anyone, but they can't be a legal person acting in a legal capacity. A support person is there to support the employee in discussions that are quite serious around their performance. They can't speak on behalf of the employee. So if people need some information about a support person, I've heard some horror stories about them taking over the meeting. That's not appropriate. You need to interact with your staff member, and you need to tell them what the issue is, how serious it is, and how they can improve, and give them an opportunity to respond to the issues.
Excellent.
So, sorry?
Mandy, we've just had a couple of questions come through, and I'm just mindful we've only got 5 minutes left. So you covered the 5 top things, so I just want to cover those off again. So we've discussed pay rates and having the checking that you're at least reaching the award, but also researching market rates. We've gone over employment contracts. You had great content in there about that. Performance appraisals, which really led into as well managing poor performance, which, as you clearly defined, that's a totally separate thing, which is fantastic. And then managing poor performance into, hopefully not, but into terminations as well. So a couple of the questions that have come through, Mandy, is, which I think you already addressed, can post-employment conditions be put into employment contracts? For example, future employer restrictions.
In an employment contract, what survives the termination of the contract is the restraint of trade and confidentiality clauses, generally. Yes. So they survive the ending of that employment contract. So restraint clauses are generally from 6 months to 2 years, depending on what the role is. And of course, any confidential information that they have or is in their possession, you need to specifically ask for that to be returned. But if there's copies and things like that, the confidentiality clause does survive the termination of the contract. They can't use that material because it's the employer's IP and things like that.
Excellent. Now the second question is, what about paying employees a flat rate regardless of number of hours worked or times worked? Is it okay as long as the rate paid satisfies the boot when compared to the modern award rate?
Yes, and the risk there is that the employee may go a back pay claim with the Fair Work Ombudsman, and what the employer needs to do is justify that this flat rate did satisfy for the hours, the penalty rates, overtime, things like that. So as long as the employee would be deemed better off overall, that would certainly be okay, and you would need to argue that case if it went to dispute. So you can do it, but you just need to be careful that they're better off overall.
Okay, excellent. Now, did you have any other final points that you wanted to deliver today, Mandy, or you've covered so much? Thank you.
My pleasure. I guess the last point is termination. So if the underperformance or any sort of serious misconduct leads to termination, it's always best to get professional advice. So I provide an on-call HR manager service. You can use it once, you can use it 100 times, but it's always best to get advice from an IR practitioner or a very dedicated HR practitioner before you terminate somebody, because they can go unfair dismissal, which is lodging an unfair dismissal claim with the Fair Work Commission, and then the onus of proof is on to the employer to prove that they terminated that person fairly. So again, you need the evidence to say that you've satisfied the procedural fairness requirements, you haven't unlawfully or unfairly terminated that person, and it's never nice to get up in front of the Commission and justify why you terminated somebody, because it's often the last resort for most employers. So always get the advice pre-termination. I would never advise a client whether to terminate or not terminate. I give them a risk factor in terms of the evidence put before me, and if it did go unfair dismissal, what their likely result would be in the Fair Work Commission.
I bet you have seen some amazing things, Mandy.
I have, and again, Shane, I'm very excited by the industrial relations arena. That's my passion, and that's where I love to work. But yeah, I do have a laugh to myself at times, and then I do worry for people who are trying to do the right thing, because ignorance is no defence under the current industrial relations regime. They are a bit more lenient towards small employers, but if you just terminate somebody because you don't like them, expect an unfair dismissal claim.
Well, thank you so much for joining us today, Mandy. If anyone wants more information from Mandy, her website is canconsulting.com.au. I got that right, didn't I, Mandy?
Yes, you did.
Excellent. So I'd advise everyone to go over there. We've also put a link in this event to your frequently asked questions page, which has a phenomenal amount of information on there. So go and check that out. So thank you, Shane, for hosting this with Otrain today and presenting this with Otrain. Any last words from you?
No, look, I just want to reiterate the importance of documenting. Mandy, thanks very much. I wasn't aware of the implied contract scenario, but I have had personal experience of paying someone a flat rate only to end up in a dispute sometime later, and the flat rate being used as the base rate because I didn't have it contracted. So we loaded up the payment in the beginning, and then had to pay penalty based on that. Documented. So reiterate, document, however formal or informal it might be, because gentlemen die and gentlemen forget, and when relationships break down, it's amazing how circumstances appear differently on both sides of the fence.
Yep, good point.
Excellent.
Well,
thanks, Emma. Thanks for a great session.
That wraps us up for this Lunch and Learn. We've already started receiving registrations for our next Lunch and Learn in 2 weeks' time. Same time, same place. We've got John Bellamy, who will be talking to us about how to get the most out of your time's investment in LinkedIn. So LinkedIn's a very hot topic at the moment. For those of us in B2B, it's a must-do. So I'm looking forward to sharing more information with Lunch and Learn with Otrain then. Thanks, everyone. Have a great 2 weeks.